Having determined after thorough, rigorous legal analysis that an unconstitutional law is infringing on the rights of Virginia families, I have a duty and the authority to act to protect them and their rights. Until the courts can rule on the matter, the State Registrar, Janet Rainey, will continue to enforce the current ban, but neither she nor I will defend its constitutionality. Even as courageous Virginians have advanced the cause of equality, the Commonwealth of Virginia has too often argued on the wrong side of our nation's landmark Supreme Court cases. With Prince Edward County as defendant in the landmark school desegregation case of Brown versus Board of Education in 1954, with the Commonwealth fighting the right for Mildred and Richard Loving to marry, despite their race, in 1967 in the Loving decision. And in 1996, to oppose opening VMI to female cadets. The same legal principles that applied in those cases apply in this case today. As a legislator in 2006, I voted against the right of same-sex couples to marry. Even at that time, I spoke about the need to fight other forms of discrimination against Virginians based on their sexual orientation. But I was wrong to stop short of marriage equality. It's time for the Commonwealth to be on the right side of history and the right side of the law. So a state law and a state constitution cannot violate the United States Constitution, and I swore a duty to uphold both, and the Supreme Court is clear. The United States Constitution is the law of the land, supreme law of the land. You know, I have just come to the conclusion that I wouldn't want the state telling my son or my daughter who they can and cannot marry.